Hello, everyone, and thanks for having me today. I'll be discussing broadly the role that patents play in AI and healthcare. So, my discussion will be separated into three sections. Each will have a few discussion points at the end. I hope to tackle these questions right at the end, or perhaps if I have enough time at the end of each section. I don't have all the answers for you today, unfortunately, but I do hope that we can simulate some conversation around these issues. The first section that I'll be dealing with is role and value of patents. The second is the patentability of AI. And the third is the most exciting and the subject of my doctorate, which is AI as an inventor. So the role and value of patents. So what is intellectual property? What are patents? What are these bogey concepts? So intellectual property refers to intangible creations of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. Legal systems around the world have recognized both the moral and economic incentives to grant citizens these kinds of rights. These rights are often critical in fostering innovation and enabling trade. Intellectual property rights and registrations allow companies and people to protect their core business and research and development activities, while creating a stronger negotiating posture for licenses. IP rights and registrations also allow a company to block any competitive products, dissuade potential entrants, and clear a technological path for future market share. This is what's known as freedom to operate, essentially. Protecting IP also allows companies to build value. Intellectual property is counted as an asset when determining the value of a company and can even be used as collateral for a loan. It's important to note that patents do not grant the holder of the right to use the invention itself. It rather grants an exclusive right which excludes others from making, using, or selling that invention in the country during the life of the patent, unless there is compensation of some sort. So why are patents important? They are both moral and economic justifications for patent. On a moral level, it serves to reward those who expend effort into creating something that others can enjoy. As they put in the labor to create this invention, they should be allowed to own it and profit from it. Along with this is the idea that by granting the patent, you ensure that the invention is disclosed to the public, who can then develop that invention further or use it. The most common rationale for patents, however, are economic. The classical legal economic reason is that patents act as a shield to protect one's invention. In this way, one can recover and recuperate any R&D expenditure that was spent in creating the invention. And one can then profit from it, either by licensing or selling the patent, or by suing anyone who infringes on it. And we know in the biotech or the pharmaceutical space, especially when we're looking at drug development costs associated with trials and risk and failures, the costs associated with those are monumental. So a strong patent portfolio or a patent on valuable technology can offer strong incentives to secure investment. This is increasingly important for entrepreneurs and SMMEs. Those are small companies, essentially. We know researchers are often academics, and they're mostly concerned with appropriating immediate value from their R&D, usually by selling their patent. They aren't so much concerned with taking it to the developmental or the commercialization phase. They're more concerned with securing funding so that they can research, and then with selling the patent, and then continuing their research. However, it's important to note that beyond this traditional sword and shield rationale lies a more strategic dimension to patents that firms can and do utilize. Patents can be used as a tool to set organizational boundaries for technologies, especially in novel disruptive ones. By using patents as a tool in this way, they can essentially compete with other firms and outcompete them. It's important to note as well that there is no international patent. Patents are territorial by nature, and you are granted protection in the countries in which you file. So you would either need to file in each country that you want protection in, or you can file via the PCT route, which basically makes the process of filing in different countries a lot quicker and easier and less costly. So now I will deal with general provisions relating to the South African Patent Act, which become important in some of the other discussions. So Section 25(1) of the Patent Act refers to the patentability. So a patent can be granted for any new invention, so any novel invention. That means something that hasn't been disclosed to the public. That's important for any researcher to know as well, because if you present your invention, anything of that sort, in a conference or a colloquium like this, for example, that would render it not novel anymore. It would thus be disclosed. So any new invention which involves an inventive step and which is capable of being used or applied in trade or industry. So the inventive step is basically just looking at what your invention is and what is the closest prior art. So the prior art would be what is the step before your invention, and how does your invention differ from that? Is your invention something obvious from the prior art, or is it something that's really inventive? Did you have to squeeze inventive juices to create your invention? So some of the exclusions also important for some of the later discussions. So a discovery, scientific theory, importantly in the context of AI, a mathematical method, and a program for computer, and the presentation of information, also known as data, are excluded from patentability. Discuss the inventive step. So this is a discussion point, as I mentioned earlier. So I'll just briefly touch on it, and then at the end we can go into more detail. So of course, in many circles, there's a lot of debate around whether patents are really good for public health, essentially, because they have been known to really impact public health in a negative light. If you think about, for example, the BRCA1 and BRCA2 patents by Myriad Genetics a while ago, where they really stopped people from developing testing technologies for cancer. And if they wanted to test for the specific gene that was patented, they'd have to use the expensive ones that were developed by Myriad themselves. So of course, when you're looking at patents or anything like this, you have to keep that in mind, especially considering that we're speaking about AI in healthcare as well. Currently, South Africa is undergoing patent reform, and we have a draft IP policy that was published in 2017-2018, which also really underlies the fact that we really want to develop our patent system, taking into account some of the challenges that patents can impose to public health. It's important as well, just from an entrepreneur or researcher point of view, when you're looking at developing a new technology, you really need to do your research beforehand and figure out what the public or the prior art is. So that's called a landscaping search. You can do that via numerous public patent databases, like PatentScope being one, Google Patents being another. So there are many others as well, where you can really determine what the technology is doing, where it is going, and if there are any gaps for you to actually delve into. Next, I'll be discussing the patentability of artificial intelligence. So to start off with, I'll just be discussing the various IP rights attaching to different entities in artificial intelligence, but with my focus being on patents themselves. So to start off with, I'll just discuss quickly some of the applications of artificial intelligence in healthcare and pharmaceuticals. So really, you can use this technology to create faster and more accurate diagnoses, improve personalized treatment, and of course most medical fields are moving towards personalized medicine. Identify candidate therapeutic substances by evaluating databases. This is something that can really only happen with AI, just because of the amount of data that there is out there, whereas AI can look at everything at once. It can assist with polypharmacology. So that essentially means when you have an ailment, it usually shows itself in a number of ways, and you need to treat numerous things at once. AI can really help with determining what you need to sort all of those issues out. Virtual drug development and drug repurposing, that's a really important one. And one of the most important ones, especially considering the COVID-19 pandemic, was identifying protein structures and protein folding. So DeepMind identified protein structure, the folding mechanisms of some important proteins last year, which is really a breakthrough, something that human beings haven't been able to do for the last, I think it was 50 years. And this is really important for further medical research, such as development of vaccines. So next up is data patentable. So a single data point in itself is not patentable. Although DNA sequences themselves are patentable, only when they display a technical effect. A technical effect is basically an application that they previously didn't have. So what have you done to the DNA to give it some sort of property that it didn't have previously? An example would be tinkering with the genetic code of sugarcane to make it bitter, or make it more sweet, or make it sour, for example. cDNA is unpatentable. Some argue that DNA is genetic data, although I think the current understanding is that it is just genetic materials, although my colleagues will know more on that. So just to reiterate, a single data point is not patentable. You can, however, protect these data points in two main ways mostly. Number one, through trade secrets, and number two, through encryption. So although you can't patent a single data point, you can, however, protect the database. So you can protect the database in South Africa through copyright. So the actual code of computer programs is also protected through copyright and not patent law. But the database itself has to comply with the originality and reduction requirements in copyright. The protection offered to these databases was affirmed in the case of National Soccer League versus Gidani. These databases may be in electronic or hard copy format. So whilst these databases are protected under copyright in South Africa, in other places such as Europe, they actually have sui generis or special database rights. And this is called the European Commission Directive on the Legal Protection of Databases. So it protects the database as a whole, and it's a little less stringent than copyright itself. Non-originality isn't a complete bar as it is in usual copyright law. So here I just have some statistics for the world and some for South Africa, just to show that the patents for AI technologies just keeps getting more and more and more as the years go on. And this really just indicates that people really see these technologies as the way forward and that there's a lot of investment in these technologies. So as you can see from this, basically the trend is just upward. And in this next one is basically the main countries who patent, well, the patent applications by different countries. As you can see, the US and China right at the top as expected, with Japan and the EPO in 4th and 5th place respectively. Can't really see South Africa, South Africa there at all. And I did a little look on patent scope for AI technologies. You can look at, I looked at artificial neural networks, convoluted neural networks, and just combined all of these just to really see what are, the general statistics in South Africa. As you can see, there were 9,231 patent applications that listed South Africa as a designated country. And there were 10 patents filed within South Africa itself. That's most likely by South African inventors. You can also see the different types of companies that were applicants and the inventors, things of that sort. You can see it's mostly your electronic companies, as one would expect. Samsung and Microsoft. That is just that data again. That is that data again, the applicants. So what is patentable in AI? The usual suspects. So core AI innovations relate to fundamental new advances in AI model architectures or techniques themselves. The innovation is within a new general purpose AI technique rather than the configuration or implementation of a technique for any one application. These are the hardest type of AI inventions to protect, as they often fall close to restrictions on patenting pure mathematical models. Basically, what you're really asking is, have you developed any kind of solution, perhaps a cloud solution, and do you perhaps have a unique neural network with unique layers which provides for perhaps different applications? The second type relates to new ways of generating a training set or a training model, or training a model. Often these are crucial considerations with health data, where the lack of high-quality data sets precludes high-quality predictions and may require novel techniques to maximize the value of small or lower quality data sets. How the system is trained or how it learns, there are models and weight parameters and ways of tracking data sets, and training a neural network or an artificial intelligence system, and the way in which you do that can itself be innovative and patentable. The third most relevant category is the use of AI as a tool. For example, the application of machine learning models to solve a particular healthcare problem. This is by far the most frequent type of AI invention, and it is where the inventors have deployed a perhaps usually known type of machine learning model to a new type of data to make predictions. For example, the application of a known convolutional neural network architecture to processing a new type of image data to make a diagnosis prediction. And the last is AI-enabled apparatus or methods. So these are your usual smart health monitor or devices, etc., etc. Can I patent? So what do you need to think about when you want to get a patent for technology that you have? The first step is to identify what technologies you have that meet the patent eligibility criteria. There will likely be many different inventions that can be patentable and which qualify for other forms of intellectual property, such as trade secrets and copyright. The second step is to identify that it does not fall under one of the exclusions mentioned. And then the final step is to evaluate, number one, whether application of an AI for a specific technical purpose, for example, in image recognition, motion detection, or drug discovery, or if this is an AI adapted for a specific technical implementation. For example, the structure of the AI provides for a technical benefit when implemented on hardware. This is a more challenging one. Most people tend to, when they patent, it'll be option number one. Just because option number two deals more with the back end of the AI, which is a bit more difficult when drafting the claims. Disclosure. So what does one really need to disclose in their patent application? As I mentioned earlier, one of the key aims of patent law is for the invention to be disclosed to the public who can then develop it or use it. So in terms of Section 32.2 and Section 33.3 of the South African Patent Act, a provisional specification shall fairly describe the invention. What you really need to know of this is that it needs to be sufficiently described in order to enable the invention to be performed by a person skilled in the art of such an invention. So it's about enablement. Have you disclosed enough to allow someone of ordinary skill in the art to work the invention? So do I have to disclose personal data? So this is a bit of a tricky subject, and when it comes to PAPIA as well, it's also very relevant. It's the intersection essentially between intellectual property and privacy laws. So do I have to disclose sensitive personal information that I use as training data for the artificial intelligence? It's necessary to ask whether you need to disclose this personal information that is subject to protections like PAPIA and the GDPR. Here is an example of a patent application that went before the EPO. I think this was in 2006, but I think it was approved in 2014, if I remember correctly. The main thing that you need to focus on here is the highlighted part. And really, it's just the last part. So performed by the aid of an artificial neural network having weighting values that are determined. One sec, the scene's just here frozen. That are determined by learning. Here, there was an inadequate disclosure of the type of data needed to train the neural network, other than the generic reference to using data from a wide spectrum of patients of different age groups and morbidities. The EPO held that this didn't sufficiently disclose the invention because it didn't sufficiently enable the skilled person to really work the invention. It really shows that if you're using an AI system to solve a specific technical problem, then you really need to disclose the details of how to train the AI system to address that problem. A disclosure of the type of input data for training may be necessary, not necessarily a disclosure of the training data itself, just the type of data. So how much data do we really need to disclose? This case shows a good guiding principle that if your invention relies on training data to train a neural network or an artificial intelligence to solve a specific technical problem, then you're going to have to disclose to some extent how you would train the system and identify the type of data input necessary. So my discussion points for this section. Should data subjects be entitled to a form of remuneration for providing data to be used as part of training data? So it's important to remember that currently in South African law, I think I'm correct on this, the data subject does not actually own their personal information. Although it's protected by acts like PAPIA, they don't actually own it. So should they really be entitled to some form of remuneration if they provide training data for an AI system in order to train it, and the resulted invention is then subject to intellectual property rights, which can then be very profitable? The second discussion point is, oh, I mentioned this, no? You can also have different kinds of intellectual property rights over personal data. As I've written there, you can have copyrights over images for facial recognition in health diagnostics. So basically, if you have some kind of device in a diagnostic that takes an image or takes a picture of a person who wants to be diagnosed, perhaps something like pink eye, something of that sort, you would then have the copyright over that image, despite the fact that that data itself doesn't belong to you. And interestingly enough, you may be required to destroy data which you have IP rights over. It really depends on what the consent was obtained for and whether that data has really been de-identified or whether it can be identified. As you know, in PAPIA, you need to have informed consent and also specific consent. And now to the really exciting bit, which is basically considering AI as an inventor. So since 2017, an AI system called Davos has really been in the news. So Davos itself was listed in multiple patent applications throughout the world, including South Africa, the EPO, which is in Europe, and the USPTO, which is the United States. Europe and America have both basically rejected those patent applications, basically stating that an AI cannot be a patent, an inventor for the purposes of a patent, simply because an AI does not have legal personality, which is the ability to bear rights and interests or obligations. And the legislation itself really disallows any AI system from being an inventor. So a lot of the legislation uses pronouns such as he and she, and that was interpreted as applying only to natural persons. Whereas in South Africa, South Africa was actually the first and only country still to have granted the patent with the artificial intelligence system Davos being listed as the inventor. The applicant, or the patentee, the holder of the patent essentially, was Dr. Stephen Thaler. So he was the owner of Davos itself and the programmer and controller. So really, from a South African point of view, this is really important because some of my colleagues touched on the fact that we really need to develop our laws in order to take advantage of AI. And in the innovation and creativity sector, it's really important to really capitalize on the ability of AI to invent, especially if you're looking at it in healthcare. So there are many challenges in our current patent law. We have some of the same challenges that the US and the EPO have mentioned previously, but there is enough room to argue that AI can actually fit the bill for inventorship if you take a more lenient approach to interpreting the legislation itself. This is the Davos patent application as published in the South African Patent Journal. As you'll note here at the bottom, it says under footnote 72 that Davos, the invention was autonomously generated by an artificial intelligence. So the discussion points to this. Given that South Africa has a dearth of innovation as really put forth by many of our policies, including the draft IP policy in 2019, where our innovation chasm was really highlighted by the fact that we don't really produce many PCT applications, so PCT applications that stem out from South Africa. And given the fact that we already have a really great privacy framework, should we not be looking at AI as being included as an inventor? Should we not, for the purpose of patent law, especially considering that if there is no inventor currently, that the invention, any resulting invention itself would not be patentable? Or perhaps a different line of thought, which I'm currently exploring, is whether a sui generis protection would be a better option than patent law. Rather than trying to really develop patent laws all across the world to squeeze in AI, perhaps we should consider something else. And now may be the right time to do that, simply because we can consider a lot of these other issues that I mentioned before, such as patents affecting public healthcare and things of that sort. We can really take these things into account when developing a new system. So my key takeaways from this talk is basically that patents are valuable at all levels in the innovation chain, and there are many aspects of AI that are patentable or protectable via other forms of IP laws, and that AI is posing challenges to our traditional IP system, just like it is with our other legal systems, and that our laws really do need to catch up, especially if we want to compete with some of the other more developed countries. And that's it for me. Thank you so much.